applicants chapter of the ACS. So we have two great speakers for you today, the first of which is Professor Josh Blackmon. Professor Blackmon teaches at South Texas College of Law. He specializes in law and technology as well as constitutional law and has put out 2 books with respect to constitutional law and Obamacare, and is also an adjunct scholar at the Cato Institute. Professor Schwinn teaches at Chicago's own John Marshall School of Law. He's also a constitutional expert and is a regular contributor to certain branches of the ABA and also a co-founder of his blog, the Constitutional Law Professor blog. So with that, we'll get started.
Thank you so much. Thank you. It's a pleasure to be here at Chicago, Kent. Always lovely to be in Chicago. My flight tonight was canceled, so I get one more night to spend with all of you. The title of my talk is Restoring the Lost Confirmation. And my goal here is to discuss how originalism can play a stronger role in the confirmation process and actually make it better. So 2 years ago, during a speech nominating Merrick Garland to the Supreme Court, President Obama faulted Democrats and Republicans alike for their prior position on judges. There's been politics involved in nominations in the past, Obama said. He's right. Over the past 3 decades, presidents and senators from both parties have ratcheted up the tension of Supreme Court nominees. And the linchpin of that conflict is what's become an utterly meaningless ritual, the confirmation hearing. But not for the reasons that you may think. The conventional wisdom maintains that in their current form, judicial confirmation hearings serve no meaningful purpose. This is because nominees who are rationally self-interested in being confirmed refuse to answer any questions that could jeopardize their prospects. Instead, the theory goes, when asked a controversial question, the nominee equivocates and obfuscates. Prospective judges nominated by presidents of both parties are trained through rigorous murder boards to provide answers that are designed to shed as little light as possible on how they'll behave if confirmed. The end result was accurately characterized by one legal scholar 2 decades ago. She wrote, "When the Senate ceases to engage nominees in a meaningful discussion of legal issues, the confirmation process takes on an air of vacuity and farce, and the Senate becomes inescapable of either properly evaluating nominees or appropriately educating the public." Who was that scholar? Her name was Elena Kagan, who's now in the Supreme Court. Perhaps because of her astute awareness of this phenomenon and to ensure her own confirmation, the former Harvard Law Dean and Solicitor General did what all nominees do, refuse to answer questions in any meaningful sense. This conventional wisdom, however, is based on an incomplete account of how confirmation hearings have developed. While the platitude that the dysfunctional state of the confirmation process stems from the nomination of Robert Bork to the Supreme Court is surely true, there's a widespread misunderstanding of what happened at the Bork hearings. The core problem is that the types of questions asked by both Democrat and Republican senators are the sorts of concerns that appeal to legal realists. The emphasis is on legal results, not on legal reasoning, and on cases the court has decided rather than clauses of the Constitution. In short, each side is trying to get a hint of how the nominee will rule on issues the senator cares about, rather than inquiring into their views about the Constitution. This emphasis on results rather than reasoning, on cases rather than clauses, is slanted towards living constitutionalism. But the original meaning of the Constitution may yield unpopular results for one side or the other. Okay? What went wrong with Robert Bork was that his original intent approach appeared to threaten too many past precedents and future results that Democratic majority in the Senate cared about. So from that debacle, candidates have learned to adopt 3 moves, which I'll be talking about today, that allow them to skate away from questions about results. These moves have rendered the confirmation hearing all but pointless. By focusing on the meaning of the clauses of the Constitution, rather than the cases of the Supreme Court, however, a handful of senators could steer the hearings toward the solid ground of legal reasoning, rather than the shifting swamps of legal realism. So let's talk about these 3 moves that have become very prominent during confirmation hearings. So first, Judges profess a fealty to the Constitution and to its original meaning, but especially to the more general principles underlying the text. The second move is profess fealty to stare decisis, a commitment to legal precedent, even when, especially when, the court's precedents have deviated from original meaning in ways that meet with contemporary political approval. And the third move requires that when asked to apply any of the court's precedents to the current cases or controversies of most concern to the senators, the nominee must decline to answer on the ground that the case may later come before the court. Through this approach, the justice to be delicately follows the committee's lead along this confirmation process tightrope, saying just enough to bolster the confidence of senators from the nominating president's party, while providing as little ammunition as possible to senators from the other party. Justices have been perfecting this balance for 3 decades now, but recent confirmation hearings have been master classes in how to give the answers while revealing nothing. Senate confirmation hearings in the post-Bork era demonstrate several disquieting trends. Republicans and Democrat nominees alike have all professed fidelity to the text of the Constitution, to the principles it establishes, if not to its original meaning, but in the same breath profess a greater fidelity to the precedents that the Senate values. Adhering to stare decisis helps both Republican and Democratic nominees avoid awkward questions about areas where the Constitution's original meaning might lead to unpopular results. When coupled with a refusal to answer questions about any issue that might come before the court, that's the magic words, might come before the court, confirmation hearings have been drained of any ability to generate answers that could either help to fairly assess, let alone oppose the nominees of either party. This unfortunate state of affairs is made possible by the fact that both Democrats and Republicans unreflectively embrace a legal realist approach, if not to the Constitution itself, then to the practice of constitutional law. In essence, both sides believe, or act as if they believe, that the Constitution is only what the Supreme Court says it is. As nominees, the Constitution is whatever the Supreme Court has said it was in the past. But here's the key. After their confirmation, the Constitution is whatever they wish it to be in the future. So there's a disconnect. They stand by precedent, but when on the court, no longer bound by those precedents. So today we live in a legal world in which many progressives and conservatives, Democrats and Republicans alike, share the legal realist preoccupation with the just result that accords with one's political convictions. So justices must be chosen who will reach the politically correct result, or be opposed because they will reach the wrong result. This is what happened with Bork. Judicial confirmation hearings are thereby turned to a game of gotcha. Questioners try to trip up the other side's nominees, and nominees quite properly refuse to reveal the only thing their inquisitors on both sides truly care about, how they would rule in particular cases that are likely to come before the court. Supreme Court confirmation hearings do not have to be about either results or nothing. They could be about clauses of the Constitution, not cases, about reasoning and not results. This reality could be achieved through some modest changes in the way that senators ask their questions. For example, instead of asking nominees how they would decide particular cases, senators should ask them what they think about various clauses of the Constitution mean, separate and apart from any Supreme Court precedent. It's too easy to merely cite a case and dodge the difficult question. The questions may be straightforward. Does the original meaning of the Second Amendment protect an individual right to keep and bear arms? Not asking was Heller correctly decided. What was the original meaning of the Privileges or Immunities Clause of the 14th Amendment? Not was Slaughterhouse correctly decided. Did the 14th Amendment incorporate the Bill of Rights, and if so, how and why? Does a necessary and proper clause delegate a limited authority to Congress so long as the exercise is convenient for the legislature? Does the Ninth Amendment protect judicially enforceable unenumerated rights? Where in the text of the Constitution is so-called spending power, and does it have any limits? None of these questions should be answered by referencing a specific case. Additionally, senators need not ask how the meaning of these clauses should be applied in particular circumstances. These questions will be avoided by move 3 anyway. They can just dodge the entire issue. They should simply ask about the meaning itself and how it should be ascertained. Do nominees think they are bound by the original public meaning of the text? Even those who deny still typically claim that original meaning is a factor or starting point. If so, what other factors do they think a justice should rely on to interpret the meaning of the text? Senators should even ask questions that today seem resolved, for this provides a window into the judge's philosophy. For example, a senator could ask whether we the people in the Constitution's original meaning included free blacks and slaves. Abolitionists like Lysander Spooner and Frederick Douglass contended that it did. Chief Justice Roger Taney denied that in Dred Scott v. Sanford. The answer to this question will tell us far more about a nominee's approach to constitutional interpretation than routine questions about Dred Scott and Brown v. Board of Education. Given that this is hardly a case that will come before them, on what grounds could nominees refuse to answer such questions? Would it be unfair to ask nominees to the Supreme Court what they believe the Constitution means and why they believe it? Such questions would certainly be challenging, but why should we not expect judicial nominees to have studied the Constitution before they are given life tenure to interpret and apply it? And repeating the catechism of previous Supreme Court decisions is not the same thing as opining on the meaning of the Constitution itself, unless you assume, of course, that the Constitution really is what the Supreme Court says it is and nothing more. I don't subscribe to that. If confirmed, nominees will get to vote whether they think these previously decided cases were rightly decided. It is essential to understanding the knowledge and perspective on this history before the Senate elevates them to the High Court. Inquiring into clauses, not cases, would also require senators to learn about the original meaning of the Constitution. Beyond hearing the nominees' answers, it would be enlightening to hear what the members of the Judiciary Committee think about these topics. Such a hearing would not only be entertaining, it would, but also be informative and educational. The benefits of such an originalist confirmation hearing are manifold. Now, I harbor no illusion that members of the Senate Judiciary Committee all possess sufficient knowledge to meaningfully engage this line of questions, beyond reading prepared questions from staffers. The problem with these pre-programmed lines of questions is that savvy members can easily throw the senator off with a discourse on a related topic and never get back to the question. Chief Justice Roberts and Justice Kagan did this masterfully. Justice Gorsuch, not quite as so. But we don't need a cadre of originalist senators. The beauty of this approach is that no rules need to be changed. No bipartisan agreement needs to be reached. And the Republicans on the Senate Judiciary Committee need not even all agree with me. For this approach to restore the lost confirmation hearing, we need only a senator or two to focus their limited time on originalism. And we have full confidence that the Judiciary Committee counsel of both sides are quite capable of generating useful questions for the nominees. Now, imagine if a handful of senators, perhaps Ted Cruz, Texas, or Michael Lee of Utah, they're both Supreme Court clerks themselves, grilled the next justice to be on the questions we asked above, right? Whenever the nominee reverts to discussing case law, the senator might interrupt and say, excuse me, Judge, I'm not interested in precedents. Once confirmed, you can change all that. I want you to discuss matters you can't change, like the Federalist or the Anti-Federalist papers, Blackstone's commentaries, the records of the Federal Convention, the records of the ratification of the 14th Amendment, and other contemporaneous sources. Any effort to shift back to citing cases should be swiftly halted. Now, most nominees probably can answer these questions, but some might not be able to. If a justice actually has a fairly rough going, that they're unable to answer these questions, it would make a really, really significant change. Okay? And I actually want to finish where I started with and go back to the Bork Year, right? Why did the Robert Bork hearing not work? Now, some of you probably weren't alive when this happened, but in 1987, Justice Lewis Powell retired from the Supreme Court. And President Reagan's first nominee to replace Powell was Robert Bork, a judge who was on the D.C. Circuit Court of Appeals. Now, Robert Bork was a prominent conservative, well-respected judge, very intelligent guy, no doubt about that. But his hearing didn't go so well. Why did it not go so well? Because in many cases, his views on the law rejected long-standing precedents. And there's one such case you probably studied called Reynolds versus Sims. Okay? This was a case about districting. And it established the principle of one man, one vote, right? You couldn't have a huge district with very few representatives. It didn't work. Bork said that decision was basically made up of whole cloth, that there was no basis for it. And there was one segment where Senator Ted Kennedy, challenged Bork and said, wait a minute, how can you say this decision is not right? The people, the American people accept this decision. Kennedy was actually correct there. So what do you do then, right, when you have a senator asking these questions, and the answer the justice-to-be gives is not something that people want, right? And this is why so many nominees took the lesson from Bork, and they decided not to go out on a limb and get any meaningful answers, right? The problem is not that Bork answered too many questions, but the problem was he answered the questions incorrectly. He showed discomfort with certain cases concerning substantive due process, as well as voting rights and free speech, that helped ensure his defeat. Right? After Bork's nomination failed, President Reagan's next nominee to fill the seat was Judge Douglas Ginsburg in the D.C. Circuit also. Alas, Judge Ginsburg withdrew his candidacy because it came out that he had smoked marijuana as a faculty member at Harvard Law. Now, that seems quaint today, right? It might actually be a job qualification today, the fact that you smoke marijuana, but not in the 1980s, just say no. Now, for the third choice, the president settled on Judge Anthony Kennedy of the Ninth Circuit. Now, Kennedy would not make the same mistake as Bork. And he answered questions in a very different fashion than Bork did. For example, in a response to a question from Senator Leahy about substantive due process, Kennedy said, with respect to the right of privacy, we are very much in a stage of evolution and debate. I think that the public and the legislature have every right to contribute to that debate. The Constitution is made for that kind of debate. Kennedy was signaling in advance the sort of jurisprudence he brings to the court about open-ended interpretations. Now, you might not be surprised that Kennedy gave these kind of answers. You'll be surprised though by Justice Thomas, whose hearing happened barely 4 years later. Now, today, Justice Thomas is probably the most conservative member on the bench. He looks askance at substantive due process, thinks it's all judge-made gobbledygook. But in 1991, where he was going through the hearing, he gave a very, very different type of answer. Joe Biden, who was then senator from Delaware, asked whether Thomas would apply the framer's notion of original intent of natural law as a mode of constitutional interpretation. Thomas replied he would as part of the inquiry. However, he stressed that the notion of liberty in 1787 doesn't stop there. It is not frozen in time. Our notion of what liberty means evolves with the country. It moves with our history and our tradition. That's Clarence Thomas, probably the strongest originalist in the court. Yet when faced with these questions, he went on this entire rant about evolving law and decency and all these sorts of things. So the upshot here is I'm basically giving a theory, right, of how these hearings can be held. Nominees who are rationally self-interested won't do what I'm telling them to do because they don't want to risk it. That's why, to the extent that change comes, it's not from the nominee, it's from Article 1. It's from the Senate. And only if the Senate pushes nominees to answer these questions in the fashion I suggest, will this process change. Otherwise, we're stuck with this vacant, empty process where these nominees repeat platitudes, these hackneyed expressions with no actual meaning. And unless that happens, right, unless senators push it, this process goes nowhere fast. I'm going to stop now, let my good friend Steve Schwinn from John Marshall offer some comments, and we'll have a discussion after that. Steve, you want to come up?
Thanks, John.
Thank you so much.
thanks to the Federalist Society, the American Constitution Society, and Professor Blackmon for coming all the way here to these very cold climates. We appreciate it. Josh, thank you. Wonderful to have a chance to interact with you again. My favorite interlocutor, bar none, Head and Shoulders. Yes, I truly enjoy these, so we've got to get you back to John Marshall soon. I teach constitutional law, First Amendment, and human rights at the John Marshall Law School. And where I focus my scholarship and my practice is looking institutionally, and particularly at separation of powers issues and how they protect individual rights. And I say this just so that you know what my orientation is, that I'm looking institutionally at the confirmation process and to see where we can figure out ways to tinker with institutions to make it better, more effective, and less political in these hyper-political times. Now, what you heard from Professor Blackmon is kind of the other side of it. On the substance and on the merits, how do we ask questions best to elicit the best information from nominees? And I want to address some of those issues first, because I think I actually largely agree with his suggestions, with just a couple of tweaks. And those tweaks are this. I think Professor Blackmon offers a wonderful solution, but I think he's not given us enough salami, and I don't think he's slicing the salami thinly enough. Let me explain. First off, I agree that we ought to focus questions at judicial nomination hearings on how a nominee is going to interpret the Constitution. I really think that's the best way to do it. These confirmation hearings, as we all know, have become a sham. The process is broken, irreparably so, in my view, unless we adopt some institutional changes that I can suggest. But we're not getting the answers that we want from the nominees, and that's a real shame. It's not serving the public. Everybody, from the White House to the senators to the nominee to we the people ourselves, understand that this is a sham and really just a show. For whose benefit, it's not entirely clear. Nobody's held to account from these hearings. Nobody gets any certainly public information or public education about the Constitution is not advanced in these hearings. They're broken. So what do we do? Well, I agree that we need to start asking nominees questions about how they'll interpret the Constitution, what their methodology is in ruling on cases, but I think we ought to ask them more than just their originalist approach. That's where I think we need to offer more salami. Here's what I think we ought to be looking to. We ought to be looking first and foremost to text, and I really like Professor Blackmon's idea about asking about particular clauses in the Constitution and how a nominee would interpret those clauses. We need to look at text. We need to look at history and indeed originalism. I'll have more to say on that in a second, but yes, we need to look at originalism. We do need to look at precedent and stare decisis. And whether we get answers from the nominees or not, it's important to press them on these questions because, as we know, the Supreme Court relies on precedent when it issues its own rulings on the Constitution. Reliance on precedent is a commonly accepted modality of constitutional interpretation, and I think we do need to include that in the hearings. We also need to ask them about what they think about past practice. What I tell my students is a commonly accepted modality of constitutional interpretation, particularly when we're talking about presidential action, is what prior presidents have done in the past without pushback from Congress or the courts or we the people. We understand in constitutional law that what prior presidents have done in the past without that kind of pushback is a good indication of what a president can do today constitutionally. I call this practice as precedent, and I think it's important to understand what judicial nominees think about that as an interpretive method. And then finally, we need to look at the more controversial areas. We need to look at prudential considerations and we need to look at ethical considerations because, like it or not, those come into constitutional interpretation on both sides, both the progressive side and the conservative side, and we need to understand what nominees think about those things. So we need to ask more questions about a range of constitutional interpretive methods. Now, let me talk about originalism just for a second. I entirely agree that we need to ask about originalism, but we need to ask more than just originalism. We need to ask what originalism? Are we looking at original intent, original understanding, original meaning, original intent of the framers, the ratifiers, the founding generation? Who, right? Whose intent matters, whose meaning matters, whose understanding matters? Or are we looking at a living originalism? When we're using originalism, what text matters? Do we look at the Federalist Papers as an originalist source? Do we look at the Anti-Federalist Papers as an originalist source? If we look at the Anti-Federalist Papers, what do we make of them? The Anti-Federalists lost the debate, so what do we make of the Anti-Federalist Papers in interpreting the Constitution? What light do they shine on our interpretation of the Constitution? I think it's important that we understand what nominees think about that and that they have given thought to these questions. Not sure they always have, but we need to understand where they're coming from. So I think there's broad agreement that we need to ask questions about interpretive methods. I think where there may be some fine differences is what are the acceptable interpretive methods and how do we ask about originalism? Let me talk about some structural issues that I have on my kind of to-do list. And I just want to start by reiterating, this is a broken process. It may be irreparably broken, but the brokenness of the process is all tied up with the brokenness of our politics these days. In this hyper-politicized environment, we can't get anything done, right? Least of all, nominating life tenure federal judges who have control over such intimate areas of our lives. That's a real problem, and we need to solve it. So as an institutional thinker, I immediately think institutionally and start to look for solutions. As an international thinker, I often think about what other countries are doing to solve problems that we're faced with, and then ask the question, does our Constitution accommodate those kinds of solutions? So let me give you an example. In South Africa, the foreign constitution that I'm probably most familiar with, they have a judicial nomination committee that is independent from political influence so that the committee nominates judges that then are confirmed in a political process, but the initial nomination comes from a politically independent commission or committee. As it turns out, a lot of countries do it that way. It seems like maybe not a bad idea. Now, in the United States Constitution, we don't have a placeholder for exactly that kind of independence. And what we've done as a result is kind of patchworked independence around things like the Appointments Clause, right? And we know that because we're following the Special Counsel Mueller's investigation and asking, what does independence mean within the Department of Justice? Is the Department of Justice itself independent? Is the FBI independent? Is Mueller independent? And what does independence mean in our constitutional system? As it turns out, other constitutions have done a way better job of thinking this through than our Constitution, and have actually included a placeholder in their constitutional text for the kind of independence that we try to emulate through institutions like the Special Counsel. So maybe we can learn from this, right? And in some ways, we have tried to learn from this. We've tried to develop a kind of institutional check on the judicial nomination process through institutions like the American Bar Association. That's kind of fallen apart, and entirely fallen apart in the Trump administration, but maybe that's the kind of thing that we can reinstate. So here are my prescriptions. First off, let's have an independent judicial nomination commission. We see this in foreign governments. We see this in many states in the United States. We actually see this, and this may surprise you, we actually see this in many Senate offices that have their own sort of independent nomination commission in order to determine the people that they're going to nominate to the president, who will then nominate them to the federal bench. This is not a bad idea, and as I mentioned, the American Bar Association historically has served this function. The ABA is an independent nonprofit, independent of the government, that is. It's nice because it allows civil society to get involved in the process in a meaningful way. What the American Bar Association has done historically is to rank judicial candidates as qualified or well qualified or not qualified. and sent the qualification determination up and allowed the president and the Senate to kind of work its magic from there. I think we could go a step farther, and maybe the right institution isn't the ABA, maybe it's a different civil society institution, or maybe it's a government institution itself that we can design in the way that we've designed so many of these institutions to be politically independent at both the federal level and the state level, to either suggest judicial nominees or to rank or somehow grade judicial nominees, or otherwise provide advice on judicial nominees to the White House and to the Senate so that they can make better informed decisions. So that's my first prescription. My second prescription is that we need to do more to encourage meaningful consultation between both ends of Pennsylvania Avenue. There's no reason why the White House and the Senate aren't talking to each other more. We've seen the breakdown of some historic practices in the Senate that have led to this kind of breakdown in consultation and communication, and I think re-implementing them is not a bad idea. One of those processes is the blue slip process. Do you know what the blue slip process is? Anybody? So blue slips are when the president nominates a judge from a state, the two senators from the state have an opportunity to object to the nomination by not returning what's called a blue slip, not returning a blue slip that would indicate that they favor the nominee. Historically, if both senators from the state didn't return a blue slip, the Senate wouldn't take up the nomination. And this worked on a fairly bipartisan basis for a long, long time. It started to break down in the Obama presidency, and it's broken down, well, kind of broken down in a funny way now in the Trump presidency, and it's broken down for partisan reasons. And what that means now is that the Senate isn't consulting with the White House as closely as they might in a bipartisan or nonpartisan way to make sure that White House nominees are going to get a hearing in the Senate. So restore the blue slip process. Second thing I can do to make sure that in both ends of Pennsylvania Avenue are talking to each other is restore a 60-vote requirement for judicial candidates in the Senate. I'm not talking about a filibuster. I'm talking about a substantive 60-vote requirement on nominees in the Senate. So they get voted out of the Senate, the Senate Judiciary Committee, and they have to get 60 votes on the merits in the full Senate. Not a filibuster, because as you know, if you've been following the filibuster issues and Senate nominations, the filibuster isn't a vote on the merits. The filibuster is a kind of cop-out. The filibuster says we're not going to vote on cloture, we're going to keep debate open, which then prevents a vote on the merits. It's used as a kind of proxy for the vote on the merits, but I think that's a big mistake and an abuse of Senate rules. If we're going to require bipartisanship in the Senate vote in judicial nominations, we ought to have a 60-vote majority on the merits. Couple of other things that we can do. If we're going to restore the blue slip process, and if we restore a 60-vote majority for judicial candidates, I think it's really important that the Judicial Committee commit to prompt judicial hearings on every nominee. Now, what I mean by that is that they don't jerk around like they did with the Garland nomination. They don't jerk around like the Senate committee did with a number of Obama nominations. If they have an opportunity to consult with the White House, and if they can use the blue slip process and a 60-vote majority, there's no good reason under the sun why the Senate Judiciary Committee, no matter who leads it, ought not be able to hold prompt judicial hearings that are public and informed, again, by the judicial reasoning of the nominee, prompt judicial hearings for the nominee. Hand in hand with that, I think the Senate has an obligation and ought to take it upon itself to give a prompt vote on the nominees. You don't get 60 votes, you don't get confirmed, but at least give the nominees a vote. I think the whole thing with Merrick Garland was a travesty, and what we've seen, as Professor Blackmon outlined, going back to the Bork nomination, we've seen this kind of tit for tat where the parties are playing this game and just kind of upping the ante with each administration and each Congress, and the result is where we are today. It's very destructive. There are a couple of things that we can do outside of the nomination process that I think would help this along. Now, some of these are constitutional, or the Constitution would allow them, and others would not, but I think they're things that we ought to be thinking about. So, for example, one, I would suggest that within any level of our federal court system, we increase the ability for judges to rotate around. We sometimes see, for example, district court judges sitting by designation in circuit courts, or say a Sixth Circuit judge sitting by designation here in the Seventh Circuit in Chicago. I think we ought to do more of that. I think by cross-pollinizing ideas around circuits and districts, I think we do a much better job of allowing judges to get to know each other. We do a better job of circuits not getting the reputation like the Fifth Circuit has as outlandishly conservative, or the Ninth Circuit has as outlandishly progressive. We are a nation, after all. We ought to act like one in our judiciary. Another thing I think we could do under the Constitution is, instead of deciding cases at the Supreme Court by all 9 justices, have panels at the Supreme Court and have them rotate and assigned randomly. And then in important cases, they can appeal to the full court, maybe with some standard of review. This is going to, again, allow kind of cross-pollination of ideas. It's going to allow the Thomases and the Alitos and the Gorsuches to work more with the Breyers and the Kagans and the Ginsburgs on the court, because they're going to be randomly bumping into each other on 3-judge panels from time to time, and they're going to have to figure out a way to work with each other. And then finally, one thing that I think we can't do under the current Constitution, but a number of other countries have done with great success, is impose term limits on their judges. So judges actually are insulated from ordinary politics because they cannot be terminated except for some kind of impeachment. But on the other hand, they serve for a limited term. That way we keep fresh ideas on the federal bench, we keep new people coming on the federal bench, the sort of ideas rolling over, and get a greater diversity of views on the federal bench. So I think those are 3 things that we can do that are outside the confirmation process that would nevertheless allow us to have a better confirmation process in the end, and one that is more directed toward a kind of judicial reasoning that Professor Blackmon suggests, and I entirely agree with. I think it's a wonderful suggestion, looking at the judicial reasoning of the candidates. So I think with that, I'm going to stop. And maybe we can just have a Q&A, discussion, whatever you guys like to do. Thanks.
That's excellent. I actually had a proposal along the lines you suggested. I wrote this last year. We all know what the shortlist is, right? President Trump put out this list of 20 or so people he would put in the Supreme Court. Now, this list is not a surprise. These names are known quantities. Why can't the Senate have their own shortlist? Follow me, right? What if the Senate, in anticipation of a vacancy, holds a series of votes on, let's say, 5 candidates, 3 names put forward by the majority party, and 2 names put forward by the minority party, and each of these 5 candidates gets a vote, and they go to the president, we vote on these 5 people. Person A got 70 votes, person B got 60 votes, and person 5 got 20 votes, right? Here. It's basically telling the president in advance, in a non-binding way, how various people would shake out. So rather than the president putting forward a nominee and just hoping to God it works, right? Maybe it'll go through, maybe it won't. The Senate can actually reclaim its role in having it it's not binding. I'm not saying it's binding, it's a resolution of the Senate saying, we view this person as worthy of nomination, we give them 65 votes, and this person gets 52 votes. And then if the president's smart, which, never mind, but if the president's smart, he'll say, wow, I'm going to pick the person with the most votes. Or he'll say, I'm going to pick the person who did have the most votes, and there's a political price to pay for that. So the Senate, the Constitution says the Senate's role of advice and consent. Today they only provide consent. They say yes or no. They need to provide, I think Professor Schwinn said, advice, right? Do the first half, advice and consent, give their advice about who they think the president should nominate. Now, there's a funny story, though, that reason why this probably won't happen. This goes back to the Washington administration, all the way back to the very first years of our republic. And apparently, President Washington was considering a treaty. I think it was the Indian tribes or something. And he went to the Senate and said, I want your advice on how this treaty should be ratified. And all the senators started asking all these questions. And he said, well, I have my Secretary of State who will answer your question. They said, no, we need to form a committee to study this. And we need to do this and this. And apparently Washington got so angry. It's like, I'm here. We need to do this. Why are you wasting my time? He never went back to the Senate to ask for advice ever again. So what I'm proposing is probably irrelevant because the Senate, by definition, moves in a very deliberate, slow process. But to the extent the Senate has a bigger role in this, I think everyone's better off. It's not just the president's pick.
And that's a constitutional thing that the Senate could do now
Absolutely.
without any
no
amendment,
changes
no
needed.
change whatsoever.
No, absolutely.
And if the Senate were to publicize its list and its votes on the list, then that puts the political pressure on the White House.
Exactly.
Yeah.
Exactly. It puts the burden on the White House to show why are we not picking the person who got 70 votes instead of the person who got, say, 51 votes. The other cost is, though, senators are lazy, and they don't like taking unpopular votes. Can you imagine taking a vote on a person who has zero chance to be put in the court? Right. But the reason why I like it is you get the majority 3 votes and the minority 2 votes. And frankly, this isn't only at the Supreme Court. I would like this to be for circuit nominations, right? Mm-hmm. Let, for each circuit nomination, put forward 2 from the majority party, 1 from the minority party, and have this advisory. It's not binding, an advisory vote in advance. I would like that much better, because right now the process sucks. Steve said it very well. It's a terrible process. You have qualified people getting hung out to dry, and they have to debase themselves with these idiotic questions about, God, it's bad. But make this process great again. Sorry, couldn't help it. All right, and I'll stop there. See, now it's snowing. That's why my flight was canceled. And I'll go to questions from the students. Thank you. Thank you so much.
Thank you.
You can clap. It's okay. Yeah, it's okay. Over there.
Yeah, so you mentioned polarization politically. Bork's book, Political Psychology of the Law, even points to this that it came out with after that hearing. So I would ask each of you to respond to a couple critiques about how certain steps in your process, I'm not sure I'm convinced that would get rid of a political sort of game. So first of all, I'm not convinced that methods are actually as apolitical as we think. So we're pushing back on, let me show you reasoning, methods, how do you decide these things? I think those are, in their very nature, have also become politicized. So I'm not sure that would get rid of the problem of giving sort of like vacuous platitude answers. The second thing is with the nomination process, even though it starts out apolitical and we get rid of that heuristic of, oh, it's from party A or B, it then goes back into, right, and now we're back to square one with, well, sure, it goes back into this political process, then they're asking about methods, which then they can pick up on those heuristics. Yeah. And then the third part would be the blue slip, which I'm not sure would be broken down by anything that's not just party line. So for instance, how are we going to get someone who might be a very good qualified justice out of Illinois when we have Democratic senators with a high incentive to make it look like the Blackmon to shut down the nomination. So could you guys respond to those?
All right, and actually, if anyone needs to leave, just go because it's really distracting. So just get up and go if you need to go before I start speaking. I shamed you all. Good.
Good. I think those are really good questions. So let me see if I can address them one at a time, and I'm sure that Josh will have a different view. Yes, I think you're exactly right. Interpretive techniques are highly politicized today, and that's why I think it's really important that we don't just ask about originalism, but really drill down and figure out what style of originalism, how you do your originalism to a particular nominee, right? I mean, I've made originalist arguments that are quite progressive. Josh has made originalist arguments that are quite conservative. Originalism today has an affiliation with conservative political thought, but I truly, in my heart of hearts, believe that's not quite right. I think we missed it. So I want to know more about what nominees think about originalism and how they do originalism. That doesn't completely solve your problem, but I think that it at least publicizes, or potentially publicizes, a little bit more information about what the nominee is thinking. That requires the senators to be on the ball, to actually know something about originalism, for example, and to be able to engage with the nominee at a deeper level. So we're asking more of our senators. We're also asking more of our nominees, because I'm not sure that all nominees could do that, but I think they ought to. As to an independent nominating commission, we've had mixed results with these, I think, as you've suggested. We see them operating in redistricting in several states now, and sometimes that works out, and sometimes it doesn't work out. Sometimes it turns out that the commission, as apolitical, turns out to be just as political, even more political than the state legislature might have been in drawing district boundaries. I would expect that that would be true with the Judicial Nomination Commission as well. Part of all of this, I think, hangs on the goodwill of the parties, right? Where I start worrying about institutions is where parties put parties before their institutional interests. And that's where I think we have a breakdown of separation of powers. That's where I think we have a breakdown of institutions like an independent judicial nomination commission. And that goes to my response to blue slips as well. I think blue slips is a tradition that can work, but it's only going to work if you've got the good faith of the parties. And it's a little bit of a prisoner's dilemma, right? Both parties understand that if they start playing politics with blue slips or a judicial nomination commission or with questions about originalism, that they win, right? Even though we might win more if we did it the right way, right? And so that it's that prisoner's dilemma, I think, that's led the parties to behave in the way that they have. And I'm not quite sure I know how to crack that other than changing the culture.
I don't want to run out of time. Are there other questions? I can answer your question later. I'll make sure someone else gets a stab.
Absolutely.
Yes, sir.
I agree. Regarding the shortlist idea that was presented, which I actually think is a really compelling way to somewhat fix, not entirely, but get into a better standing with how the nomination process works. How about, like, what necessarily stops the president from saying he has a list of 5? Why not skip the whole list, pick a completely unique person not on the list at all, and just do it as always? That's one thing that I get hung up on when I try to think about it, because yes, perhaps what the person on the top of the list has like 53 votes, so enough, or 60 in the case where you guys presented it. So someone has 62 votes. Why not subject themselves to picking somebody that was picked for them and then just do it the other way of doing it? That's not very clear, but.
Well, I mean, under the Constitution, the president has to nominate one person. He can't nominate a slate.
Correct.
The question is, before he makes the official nomination, what can the president do to signal his thinking? Is that what you're getting at?
It was more like, why not avoid signaling through what the Senate has already advised? Because I understand the importance of advice from the Senate, and I agree with what you guys presented. I'm just curious why a president would just take the advice and not just take it on themselves to continue how the process is.
Well, they can, because presidency, this is their prerogative. That picking a justice is their, signature achievement. And why am I going to let some dumb senator from Illinois tell me what to do, right? No disrespect. But presidents don't want to give up this prerogative. In fact, the idea I propose would be the Senate taking power back from the presidency. That'd be the crux of this point. I don't see it as likely to happen. The one spot it might happen is in the event that there was a Republican president, Democrat Senate, and basically the Democrats are like, whoever he picks dead on arrival, here are 5 people that might get through, or the seat stays vacant for 4 years. By the way, I think if Democrats win the Senate in 2018 and something happens in the Supreme Court that there's a vacancy, I think it stays open for a couple of years. I don't think anyone. I've said this years ago, even before Scalia died. I think we have extended vacancies. I think it's a new normal that unless we have the Senate and the presidency in the same party, the seat's not filled. And that flows from the Garland nomination very, very naturally.
I think that's probably right. And some might say, well, that's okay. That's the way politics are supposed to work.
There's a question over here?
Yeah.
And this will be the last question. We're almost out of time. Yeah.
Yeah. I mean, I think you both spoke to this. But I guess my question is, if, like, in a world of hyper-partisanship and where vacancies go on for, years, 2 years, 3 years, we'll see how long they keep going. Doesn't this all kind of just be like rearranging deck chairs on the Titanic? At the point that you have, calling out conservatives that in the past 30 years have acted in fairly bad faith, not nominating people who are more centrist, nominating people who are, far right. Look at Merrick Garland and Scalia, Clarence Thomas. When Obama's last term it was Merrick Garland. It was the most milquetoast guy you can get. At the point where you have one party who just wants to pull it so far to the right, how do you get people to talk to each other?
I'll let Steve take this one.
I actually don't have a great answer to that problem. If I did, I don't know what I'd be doing, but, I truly believe this is a large prisoner's dilemma problem. And I think both parties have to understand that if they behave a certain way, they get a much greater advantage for themselves to the detriment of the opposing party. Even if they work together, we all might be doing a lot better. And in some ways, that's the way politics is set up. In some ways, that's the way our Constitution is set up. Where I object is where the parties start monkeying around with institutions in order to achieve those political results. I think that's a separation of powers problem. What I tell my own students at John Marshall is, look, you can agree or disagree with what different political actors are doing and their constitutional claims, but what you ought to do is view it from the other way around, right? So assume it wasn't Merrick Garland, but assume there was a Republican in the White House and Democrats in the Senate, and the Republicans put up a Republican Merrick Garland, and the Senate Majority Leader said, no, we're going to let the people decide. How do you feel about it then? Now, I'd like to think, well, I feel the exact same way, but in truth, I don't really know, right? Because we didn't have that.
All right, let's leave it there. Thank you all so much.
Thanks.
Thank you. That's the last word. Thank you.